Thank you. Thank you very much, Mamta, and welcome all of you in the audience, and especially you, Bharat. Thank you for taking time out. Very excited to have the session with you and get your input. You're obviously one of the more active players in the market. I think early on, somewhere about April, we wrote an article, and we said that COVID-19 brings about very interesting challenges in LPGP relationships, which we expect to be tumultuous during this time. At one end, we are seeing fund formation teams being increasingly busy. Distressed funds, credit funds, special situation funds are raising capital. But at the same time, I think there have been apprehensions as well. Apprehensions that different contributors in terms of deal apprehensions and so-called denominator effect will drive some degree of liquidity concerns, which can actually stall deal making in the market. Just to give a perspective, to those not very familiar with this, denominator effect essentially is a terminology largely taken or considered in the large LP sort of a construct, where they have certain allocations to public equities, which are liquid, and certain illiquid assets in terms of private equity and unlisted investments. And what happens is that when the stock markets tend to underperform and get depressed, the illiquid investments as a percentage of the total AUM seem to appear much larger. That sort of sends a panic signal sometimes to the LPs, and they are sometimes driven to either request the GPs not to draw down. No LP would generally default, but if an LP really makes a call to the GP and says, look, we are a little concerned and please don't draw down for some time, I think generally GPs do honor that. And we heard of some instances in the global markets from our clients that there have been instances of LP selling interest in well-performing funds at certain discounts. So I think these kind of trends sort of came up, and obviously now the situation is significantly improving with the stock market again rallying up with a lot of free money, so to say, flowing. And I don't know if denominator effect is still playing up or not, but obviously I think the theme of LP, the theme of and opportunities of LP buyouts, GP buyouts, and portfolio buyouts, driven by cheaper valuations and tremendous value creation, still emerge. I think broadly we'll discuss some of these themes. Just to quickly set out, LP buyout would mean just buying the LP interest. GP buyouts would mean buying the stake of the investment manager, and then there are portfolio buyouts, and probably a fourth category. In India, unfortunately, secondary funds are pretty limited, but where they are, I think the secondary funds are operating in terms of these three buckets, and also sometimes and another bucket of what we call as the GP support bucket, where sometimes they would set up a new fund entirely with renewed compensation structure, renewed carry structures, renewed fund life structures, negotiating with the LPs, retaining the same GP team and incentivizing them in a big way. So I think we'll talk about all of these things in greater detail from a legal, tax, and significantly a commercial perspective. I think, Bharat, if I can just come to you quickly with the first question. Do you really see significant interest in LP, GP, and portfolio buyouts? Are you seeing that on the ground?
Thanks, Ruchir. Thanks for the good setting up, the good base, and the good intro to the whole discussion. I guess, to a large extent, fundamentally, look, what drives the secondary on the ground is their ability to really churn out the predictable IRR. And what drives them on the ground is if they can actually see anywhere between 15 to 18% IRR in a recent time frame of, let's say, 3 to 5 years, that makes them much more excited to basically invest into any of those forms of investment what you spoke about, whether it be LP buyout, GP buyout, or anything. Now, in the current scenario, the good part is the public market has rebounded, Whereas in the private market, we have already basically, a lot of us have taken a big beating in terms of valuation in the Q1. This will take some time for the valuation to really go up. And overall, the private companies will take time in terms of really gain back their performance. So overall, the good assets are also, because of the liquidity crunch or because of lockdown, they are available in a much cheaper at the lower and the much sober valuations. So from the secondary perspective, this may be the best time to enter in the market. However, the real question really comes in which form they should enter and who will be the seller at this moment. So the seller could be either the LPs who's trying to manage its capital allocation and is trying to basically look for some liquidity to make sure that there's a right balance between liquid and illiquid asset. Or there would be some GPs who are basically sitting on right now with some commitment to return some funds to the LPs, and now the markets are basically becoming much tighter. So for them to basically drive the decent portion of the liquidity with the pool of few assets, secondaries could provide that right answer. Will it be immediately available or they want to sell immediately? That will be the larger question basically they need to resolve in their head. But I feel that most of the GPs or most of these portfolio managers at this moment, what they must be thinking through from their perspective is, hey, let's make sure that, okay, let's do the groundwork right now and keep ourselves ready in 3 to 4 months time down the line, so that the moment the portfolio stabilizes and we don't basically get too much hurt on the valuation looks a little bit better than what they are right now, that could be the right time. And the driving factor for them would be the liquidity in that regard. So to answer your question in short, yes, GPs, it's the best time to basically come and enter into the market for the secondary funds, and for GPs to basically to sell this thing, they may want to wait for some time. LPs may basically look to sell something to liquidate to generate some liquidity. But the last portion which you basically mentioned in your intro, which is a very interesting stuff. Let's say some of the funds which are on the fag end of their cycle in that regard. There, the secondaries can play a very active role in terms of resetting the economics for those guys and give a new lease of life to those funds. Because at this moment, let's say those funds which are in the fag end of life, it doesn't make sense for them to really liquidate the things because this is a temporary blip which may go over very soon, but that soon will be anywhere between 12 to 18 months time frame. So in that regard, secondaries could be those guys who can give the good cushion or good basically hand holding to these fag end life of the fund. So yeah, it's a good time from the secondary perspective. And if somebody is basically looking from the liquidity perspective a problem, secondaries could provide a good answer at this moment.
Very nice. Thank you very much. I hope, probably these times encourage more and more secondary funds. The market has been quite thin till now. So let's see. Great. I think, and I'll come back to you on that, Bharat. But Richie, I think, you set up large, some of the largest funds and been very active in the fund formation space. What are you seeing from from an LP buyout perspective, and what do you think should be the top considerations for LP buyout kind of transactions?
Sure. No, I think thanks, Richard. I think it's a great question, and thanks, Bharat, again for your insight that dovetails to a lot of conversation that I'm going to have. I think to begin with, India was not very high on LP secondaries or LP buyout situations. It was largely to do with the way a lot of the funds were documented. And the reason is that from a LP buyout perspective, an incoming LP would want a lot of transparency on what the fund documents are, how the reporting is done, what the portfolio is all about, and so on and so forth. A large part of the funds that were coming out for these buyout situations were the vintage 2007, 2008 type funds, where a lot of the Indian fund managers were still coming through their first or perhaps second cycles of management of the fund. So in those cases, what happened was the Indian funds were not as comparable to global funds. Eventually, when the second wave of fundraising around 2012-13 started coming in, a good part that had happened is that a lot of global asset allocators, whether it is sovereign wealth funds, institutional investors, and so on and so forth, they started participating in the funds. In some cases, there were 10 or 15% of the investor pool. or in some cases they were 60 to 70% was institutional raise. What it meant was that a lot of the India fund documents started getting more global in nature. A lot of the terms, commercials for LPs were something which were comparable to, let's say, a Japan fund or a Korea fund, or even for that matter, a California-based sort of fund, because the investors were the same and they had similar expectations from all their fund managers. So I think the first reason why LP buyout or LP secondaries became prominent was because there was some homogeneity that India was getting into from a documentation and GP behavior perspective. The second piece was that a lot of LP participation was fragmented. So LP tender, where an LP buyout fund perhaps could approach the investors, that was very, very shallow, so to speak. So which is where we started seeing the nuance where GP-led restructurings started happening, where the fund manager itself thought, okay, look here, the portfolio is having some pain in it. How do we create liquidity for our investors? That is where the GP was being approached, or the GP started approaching these LP buyout situations and sort of encouraged its existing investor base to sort of sell. Now, like Bharat indicated, in those cases, we have seen some of the products being taken up by the fund managers, where there would be a buyout of the LP positions, a new class of units or shares perhaps would be issued. There would be a reset of the fund terms, economics, perhaps relooking at how the carry is designed, how the fee should be structured, and frankly, how can we drive some more alignment between the fund manager and the incoming LP, who perhaps would understand the fund manager's position perhaps better than the initial set of investors who had joined at the time of the initial closings of the fund. So that was the first wave. But with that, what had happened is the next wave has now started coming, where we are seeing slightly more inventive situations coming up. Things like, can we have a continuation vehicle where the incoming LP sort of ensures that the portfolio gets an extended term, and even though the fund term may be about to come to a close, can we do a secondary? So I understand that we are looking at portfolio secondaries in a separate bucket, so to speak. But it largely goes back to the initial point that investors, when they commit to a fund, they have a limited timeline horizon that they have in mind. And what are the different solutions that we can come out, so that while investors find some liquidity, the portfolio is not under the stress to create an exit window, which is where situations like evergreen funds that some of our fund manager clients are operating, or continuation vehicles sort of come into play. So I think by and large, that is how the industry has evolved. There is a lot of appetite from the GP side, of course. LPs are also looking at these situations more actively. There are products being designed around these themes, but I think still some more way to go.
Thanks, Richie, for detailing the implications for LP secondary. I think my next question is to Ruchir. Ruchir, you have been involved with few GP secondary deals of late, and there were a number of issues we faced on those deals. So would you like to let us know what were the key considerations that were involved when you when you were advising the acquirer client for the GP secondary?
Yeah, no, absolutely. Thank you, Nishith. I think amongst all the buckets of LP, GP, portfolio buyouts, I think GP buyouts are probably the trickiest, in as much as they are extremely foresighted, because the consideration involved is much lower buying the investment manager, but obviously they come with a significant amount of foresight that private equity managers would buy a GP entity to grow their fund platform in India. And from that perspective, I think a lot of thought needs to be put into this. I think the first question that whenever you're buying the stake in a GP entity, or so to say the investment manager, is that, are you just planning to buy the GP entity, or will you also become a unit holder or an LP in the fund? Now, that can be in two capacities. In the Indian context, obviously, the question will be whether would you also be acquiring the sponsor units in the fund? And if at all it comes to dealing with certain LPs who are not so happy with you being the GP, would you end up buying those LP interests as well? I think that is the first consideration that should be kept in mind. And obviously, before any GP acquisition, there is a need to have commercial discussions and elementary comfort level with the base. Attendant to that question is your choice of jurisdiction. Under the Indian double tax avoidance agreement, sale of units of an AIF would not be subjected to any tax if these units were sold, by a resident of Mauritius, Singapore. And so therefore, I think the choice of jurisdiction again becomes very important. It also becomes important depending on the underlying asset class. For instance, if it's a credit fund, then it becomes important on the kind of nature of income that will be received, because interest income is taxed for Singapore residents at 15% and Mauritius at 7.5%, and obviously the whole tax regime then kicks in. So that's another consideration that people need to have in their minds on where is it exactly that they want to be setting it up. A third consideration is how should you be structuring the acquisition of the investment manager. Most of the time, the investment manager might be structured as a company, and so you can obviously do a share purchase of the investment manager. But on the other hand, considering that it's a heavily regulated entity, there might be some backlog, and the diligence, while done extensively, may not give adequate comfort. And in those situations, sometimes we've seen people opting for a business transfer agreement or a slum sale, so to say. A slum sale, by definition, means that you are transferring all assets and liabilities that are necessary for the conduct of the business. However, even from a tax standpoint, it is absolutely permissible to exclude certain liabilities. And the way these kind of slum sale transactions are structured is that all antecedent liabilities, other than which are absolutely necessary for carrying on the business, are excluded. And this would include, employee-related liabilities or other regulatory liabilities and so forth. So that's a safer way of doing it. There is a school of thought that believes that a non-compete is better enforced in case of a slum sale agreement or a business transfer, because there is clear allocation to goodwill. And as you know, under the Indian Contract Act, non-compete limits are entirely driven by the extent of goodwill. So in a business transfer agreement, because goodwill is more clearly put out, the non-compete, there's an argument to say that it may be better enforced. I think on the same count, it's important to structure this well, because allocation should be given to goodwill and not non-compete fees as much. Even though the term non-compete fee sounds very comforting, it doesn't really enhance the extent of your non-compete. It is goodwill that really is a determinant. A non-compete fees, on the other hand, is just like a revenue expense and will actually also be subject to GST. So I think these are some of the considerations that need to be thought about. The other fourth important consideration that people need to think about are the keyman provisions. When you are acquiring a GP, it is very important that the existing keyman provisions are not triggered. And those people on whom the LPs betted their money, they continue performing and devoting substantial time. So I think we need to carefully look at some of the fund documents to see that the keyman provisions are not breached and the existing keymen are substantially incentivized to continue to the best of their abilities. I think another issue, it becomes critical, and Anishil, feel free to moderate me. It's whenever you get a free chance to speak, you go on. So so let me know if I'm exceeding. And I think the other point is from an LP consent perspective, at least from an offshore fund perspective, the consent of the LPs will be determined basis the shareholders agreement or the partnership agreement or whatever entity agreement is there. From an Indian law perspective, the consideration will be driven from a SEBI standpoint. Is that there are two thresholds of 2/3 and 3/4 approval, and in most cases it will be 75% or 3/4 approval of LPs for any kind of change or a material change that you're doing. Say, for instance, you're transferring the management contracts, or you're doing any significant change in the terms, or you are doing any kind of material change in the fund documentation. I think the critical part here is that, again, the LP consent for change of control of the asset manager, and there can be many other things, but change of investment manager will be the most critical one. It is a concept of, there's a concept of deemed consent. So if, for instance, for 30 days the LPs do not approve, do not object or disapprove any sort of a voting matter, then it is deemed to be approved. And this comes in very handy when you are dealing with some of the retail funds, because when they're retail investors, it's a huge issue to get consent of 75%, and that's where this deemed consent, etc. applies. I think there are some ambiguities and nuances around these approvals. I'm not going to too much detail, but that need to be taken care of. I think the other part is, if you are actually transferring the management contract, extending fund life, or doing anything, or let's say revising the compensation structure, so to say, there may be a need to change the fund documentation. If the fund documentation were to be changed, you need to be carefully looking at how should the amendment to that fund documentation in terms of the subscription documents, etc., was put across. It was very surprising that in one of our prior deals, we saw that unlike what is customary, that a majority of unit holder approval would, could actually change the agreements. There was a terminology that, you actually needed for every subscription agreement, every unit holder or every subscriber had to approve that, and that became a huge concern. So I think the fund documentation has to be drafted in such a manner that it should contemplate a change in GP in future. Side letters are again an important aspect. Another thing that I think, which becomes relevant, particularly if it's a foreign acquirer, and that's the sort of capital providers we generally cater to, is that if it's till now, if it was a domestic fund manager and there's a foreign fund manager which is coming and acquiring, then the ownership of GP will determine the entire ownership and control of the portfolio, because the moment the GP is foreign owned and controlled, the entire portfolio then becomes foreign owned and controlled. And to that extent, issues like certain instruments which were structured as OCDs, etc., which could have been possible with a domestic asset manager, certainly become challenging. Also, in certain asset classes, there could be certain, in certain sectors, the degree of foreign investment could be challenged. The last 2 points very quickly. One is from an antitrust perspective. In most cases, it may not apply, because if your asset base is less than 350 crores and the turnover is more than 1,000 crore, generally antitrust or competition commission approvals may not be required, but we need to carefully see if any of that asset is reaching this threshold, then approvals may be required. And obviously, I think there's a last consideration of being very careful with diligence, aligning yourself with the exit timeline that was promised to the LPs. I think all of that becomes very important whenever you are considering a GP buyout. So I think that's it, Nishil. And maybe while I'm on it, Nishil, can you throw some light on portfolio buyout kind of transactions? You've done several of these large ones in the market. What are the typical consideration structures, legal and tax issues that you've encountered when looking at some of the portfolio buyouts?
Sure. Thanks, Ruchir. So just for the benefit of audience, portfolio buyout would mean sale of multiple portfolio companies owned by a private equity fund in India. So instead of just selling shares in one portfolio company, the PE fund sells portfolio companies in bulk. So could be, we have done 3 to 4 companies, we have done 8 to 10 companies also. So the interesting things about portfolio buyout deals is the first thing that we encountered when we did the first deal was the allocation of price. Now, typically what happens is that the buyer secondary fund and the seller PE fund, they negotiate a consolidated price for the entire portfolio. While for their internal purposes, they may allocate this consolidated purchase price amongst various portfolio companies. But the commercial price which is decided for various portfolio company typically has to be changed because of various issues as follows. The first issue that came up in one of the portfolio buyout deal was commercially it was agreed that for that particular portfolio company, the price should be 500 rupees per share. But what happened actually was that just a month before, some of the senior management of that portfolio company had exercised their employee stock options at a fair market value of 300 rupees per share. And immediately in 1 month's time to do the deal at 500 rupees per share, there was a concern from the senior management that they could be taxed at 500 rupees minus their exercise price as perquisite, which could entail a 35 to 42% tax for them. So they were quite concerned that the transaction price for that particular portfolio company should not be more than 300. So that was the first challenge that we faced there. And hence we had to allocate the gap of 200 in some other portfolio company to ensure that, the senior management does not face any additional tax issue. So this was a situation where the commercially agreed price was higher than the price which the senior management wanted. There was another situation which was exactly the reverse. We had negotiated a price of 400 rupees per share, but the company was going to go public in 6 to 12 months time. And the management and the promoters wanted that price to be a higher price so that when they go for roadshows, they can justify that the last transaction that happened in this company was not at 400, but at 600 rupees per share. So here was a situation where we had to increase the price to take care of the concerns of the promoters. Obviously, all these things had to be ensured that commercially and we are able to justify the increase or reduction in the price through fair market value report taken from the accounting firms or the merchant banker. But these are two interesting situations that we faced for reduction and increase in the price due to the portfolio level concerns. The third situation that we faced was there were about 7 to 8 investments which were getting transferred. And some of the investments were made prior to 31st of March 2017. The other investments were made post 31st of March 2017. Now, the investment that were made post 31st of March 2017 were being transferred at profit, and the investment which were made prior to 31st of March 2017 were being transferred at a loss. So this was the commercial price that was determined. But from a tax perspective, the grandfathering under the tax treaty was available only till 31st of March 2017. And hence we had to again reallocate some of the purchase price with respect to portfolio companies from post 2017 to pre 2017, so that for post 2017 we don't have a significant profit, and for pre 2017 instead of loss we have profit, and that profit anyways would have been exempt under the India Mauritius or India Singapore tax treaty under the grandfathering provision. So this was another interesting purchase price allocation within the portfolio companies that we had to do. The next situation which also becomes important is typically for large global funds. They invest in a particular portfolio company through 3 or 4 funds, right? So in certain companies, certain funds participate, in certain other companies, other funds participate. And hence when the entire portfolio is sold, it may not be it may not be possible that all the funds have equally participated or proportionately participated in all portfolio companies. And hence we are actually making this allocation of price or purchase price adjustment within the portfolio. We need to ensure that no fund is unduly burdened with additional like reduction in price, which otherwise it would not have got. So I think that rebalancing within the funds also needs to be done when we are doing this allocation of price amongst various portfolio companies. The second interesting issue that we faced, and that is typically faced in situations where, let's say, the portfolio companies are held through an intermediate SPV in Mauritius or Singapore, is the interpretation of whether the indirect transfer through the sale of shares of Mauritius or Singapore company is going to trigger the transfer restriction provisions under the shareholders agreement at the portfolio company level. And that becomes very critical because a portfolio company, if any co-shareholder exercises the right of first offer or right of first refusal, it could actually unsettle the entire deal, because typically, in these type of deals, there are always good portfolio companies and bad portfolio companies, and it's a basket which is negotiated, where the good portfolio companies make up for the bad portfolio companies. So if for whatever reason one good portfolio company goes out of the basket because one of the co-shareholders exercises the right of first offer or refusal, then it actually unsettles the entire deal. And hence it becomes extremely important that a proper interpretation is taken as far as the shareholders agreement are concerned on what does indirect transfer mean, and if at all there is any indirect transfer provision, is there a way to defend the fact that there is no requirement to give to make an offer to the co-shareholders of the company. And in one of the deals that we did, we had to spend a lot of time because that was the most prestigious portfolio company that the seller was selling, and there was a provision on indirect transfer, and we were actually buying for our secondary fund buyer client, the Mauritius entity. And we had to go through the entire shareholders agreement, look at various case laws on what does indirect transfer mean, when can it be considered as a sham transaction, what could be the consequences if the other co-shareholders come back and say that this should have been offered to us before the sale happened at Mauritius level. So multiple issues had to be dealt with respect to transfer restrictions. The third interesting issue which comes up is what are the rights that you are inheriting from the selling PE fund, right? Now, this also becomes interesting because sometimes what happens is that the selling PE fund may not be selling its entire stake in that portfolio company. If entire stake is sold, then it's quite straightforward where you just transfer the board seat and you transfer the affirmative rights and some of the other rights to the secondary buyer PE fund. But in a situation where only part stake is sold, then there is negotiation that needs to happen with the seller PE fund as to who will keep the board seat. As far as affirmative vote rights are concerned, how will the buyer PE funds, say be factored in the veto rights at the portfolio company level? So you need to also enter into a back-to-back arrangement with the seller PE fund that in case of these reserved matters, you will first ask me. If I say yes, then only you can say yes. If I say no, then you have to say no to that reserved matter at the portfolio company level. The other interesting issue that also comes up is the drag right. Now, typically in large portfolio companies where there are multiple investors who have come in at different stages in the portfolio company, there is always there are one or two large investors who are there in those portfolio companies, and those large investors have a drag right with respect to all the other shareholders of the company. Now, what might happen is the seller PE fund, when the seller PE fund would have entered the portfolio company, the drag right could be triggering after 6 to 7 years from there. But let's say when this deal happens, where the secondary buyout fund is buying this portfolio, where this company is also part of the portfolio at the end of 5th or 6th year, what it means is that in the next 1 year, there is a risk of the shareholding being dragged by another major shareholder of the company, and no PE fund likes to be dragged in 1 year's time. And that too, the valuation also, there would be a mismatch because the dragging PE fund would have entered at 6 years before at a very low valuation, and for them to even drag at the valuation at which the secondary buyer PE fund is coming at the end of 6th or 7th year, it will still make a lot of profit for the dragging PE fund, but for the secondary PE fund, they may actually be dragged without any profits at the end of 6 months or 1 year from the time they bought this. So that also becomes important. The other interesting issue which could also come up is the exit timelines. And sometimes it happens that the shareholders, PE shareholders who came before the selling PE fund, they may have negotiated certain timelines where their buyback or put option on the promoter is getting triggered 6 months or 1 year before the selling PE funds, put option or buyback. So that also becomes important to understand, because if at all that option is exercised, and that may be imminent because we are entering at a stage at which that put and buyback are just 6 months away, and the other shareholders have not got third party exit by then. So in that situation, it becomes important to see whether the promoter and the company will have any financial resources left to buy the secondary PE fund out in case the company doesn't do well going forward, or the only exit available is through the promoter or the portfolio company. I think the next important issue that we have seen is the indemnity. Now, indemnity becomes very tricky, especially when there are 3 or 4 funds from the basket of global funds who have invested in various portfolio companies. So let's say Fund 1 and 2 have invested in portfolio company 1, Fund 3 and 4 have invested in portfolio company 2. Now you are selling both portfolio company 1 and 2. And how do you take indemnity from portfolio fund 1, 2, 3, and 4? Because fund 3 and 4 don't have exposure to portfolio company 1, fund 1 and 2 don't have exposure to portfolio company 2. And that's where it becomes important to understand, and it becomes all the more complicated when intermediate SPV in Mauritius and Singapore are used, because you may have 2 funds investing in Mauritius company 1, Mauritius company 1 may invest in Indian portfolio company 1 and 2, then there could be 2 or 3 other Mauritius companies who may be used to invest into other portfolio companies by other funds. And that's where, how do you negotiate the indemnity package with the fund? So typically what we do is the Mauritius companies, with respect to whatever they have sold, anyways they need to give full indemnity for that. Because most of the times you will only get fundamental warranties from the selling PE funds, given that the selling PE funds in most of the situations won't be in control of the portfolio companies. And that's where it becomes important to understand that how are the ultimate LPs getting impacted, because different funds will have different LPs. So for a portfolio of fund 1, I cannot make the LPs of fund 2 indemnify in case there is a breach by the Mauritius entity on title of shares with respect to that earlier portfolio company. So I think these are some of the interesting things which are there, and specifically as a market standard, what we have always seen is the ultimate parent fund always backstops the indemnity provided by the Mauritius and Singapore entities, and that becomes very critical for the purpose of designing an indemnity package. And the last point here on this is the regulatory approvals. Most of the times, CCI approval gets triggered if the portfolio company is of a decent size, and especially now even having one director on the board of a portfolio company could trigger the CCI approval, even if the percentage is less than 10% in terms of the equity stake that is being acquired. So CCI approval becomes important when you are evaluating the entire package, and there will be sector-specific approvals depending on whether you have an insurance company in your portfolio, you have a bank or an NBFC in your portfolio. You need to take sector-specific regulatory approvals also. So I think broadly, Ruchir, these are the 5 or 6 important points that need to be taken care of when we are doing portfolio buyout deals. Hey, Bharat, you had any point to make?
No, thank you.
No, it's very interesting. I just want to basically say one thing is as Nishal basically pointed out, the issues could range from anywhere to anywhere in these kind of scenario, because ultimately, if you think about it, a portfolio amalgamation of a GP's restriction, LP's restriction, company's restriction. So together you are basically mixing and seeing 3, 4, or 5, 6 major constraints together. So what is very, very important, and in the past we have gone through one of this situation, and I could relate to a lot of points which Nishal was saying. You need to have one good partner alongside with you who is basically thinking more solution-oriented approach versus problem-oriented. But make sure there's a lot of internal restriction. You are actually clearing this beforehand. So having a good partner along becomes very, very important, because it needs a lot more creative answer, but making sure that those, and also ensuring that you are not breaching any of your internal compliance framework in any manner.
Yeah. So let me pick you on. Let me pick your thoughts, Bharat, on that point. I think it's a very simple one line question. but I think with enormous depth, which can only be learned probably by experience, is your dealings with the LP. I think it's very easy to say that what are the LP-GP relationships and what are they looking at, but I think this crisis has taught us one thing, that we cannot take them for granted. No one did. Obviously, they are the most important constituent. But I think somewhere, I think there has been a perception by the LPs, and that's across the board, that the sort of reportings and the disclosures and the kind of detailing that they wanted was not as they wanted. It was still being done, and it was still meeting the documentary requirements, but not really what was in spirit or what was really expected by some of the LPs who wanted to dig much deeper, have much more handle and influence on the transactions. Nothing wrong, but it's just that I think they were treated rather mechanically, and I think that sort of drove a lot of LPs to kind of set direct shops in India. As the Indian market has matured, they have kind of understood that in the design of what we call as the partner, the property or the asset, and the valuation of the price, in the three P's, the partner, property, and price, the partner is the most important constituent. And so to that extent, if they are able to find a great partner, I think they are happy to do deals directly. Of course, not the buyout kind of deals, but generally taking a substantial minority stake. I think this trend has largely been in in asset-heavy asset classes or predictable asset classes, not as much in tech or other kind of growth assets. But the one thing for sure which has been homogeneous is that LPs are now getting more and more involved. They are forcing GPs to be very focused on their core sectors, let go of non-core areas, and they're pretty much driving and are being the determinate force in the back end, more active than ever. And so therefore, I think LP-GP negotiations to some extent are becoming a little complicated. So we hear. But I would like to hear from you, Bharat. How are you seeing your LP-GP negotiations evolve, and what are the parameters that you would think in mind while negotiating with LPs?
So look, it's a great question, but the good part is me coming from Sequoia, we always have a legacy of 40 years behind, which makes our life a little bit more simpler in that regard, because most of these LP relationship is much more set standard. They know we would have raised along the line journey many funds, running into some 50-60 fund all across. So that makes our life much simpler because there's a set expectation on both sides of it. We don't basically increase our LP gamut to that extent. However, whatever I hear in the market from the various parties or various GPs, it looks like you rightly pointed out, LPs wants to basically get more color. LPs wants to basically remain more informed about the things. They want to know more about details about. They don't want to see one number as a valuation number. They really want to understand what's driving that valuation, what's happening on the ground. They become much more intrusive. Their interaction over a period of time, earlier they were more on the back foot, just sitting, understand, and just receiving the information. Now they are basically coming, having a lot more discussion in person with the GPs, go through the portfolio reviews in much more detail. So those things are happening a lot. Now it has good part. It has basically a bad part. Bad part on the GP side of it, a lot more onerous requirement on the GPs. But from the LP's perspective and the communication perspective, it basically opens a door that, okay, there's nothing hidden remain over there. Everything is basically good. And one must acknowledge the fact that, okay, look, these LPs, they are not the LPs only in one fund. They're LPs across maybe in 3-4 GPs, maybe from the same geography. So there is an LP who's there with Sequoia Fund, he may be the same LP with SAF, maybe a couple of other guys. So what drives a lot more curiosity at their end is how you're reporting the same asset. I may be basically portraying a different picture of the same asset, whereas somebody else may be portraying a different picture. And that basically gives a lot more curious, or that gives a rise to the curious question at their end. That makes them much more easier to go. And ultimately, our 2 cents have always been with the guys is like, look, with the LPs is like, it's better to basically over communicate versus under communicate. Better to be more reserved in your number than being a little bit more bullish, because it's a classic approach which always work is like, remain conservative, deliver more, you will remain okay. On the negotiation side of it, on the key terms and everything, look, India was a different stature in 2006. After that, a lot of people raised the money in 2006, 7, 8 timeframe. There was remained a lull over the few years, 4, 5 years. Then 2012, 13 came over in another window, and after that, like India has seen quite a few basically GPs raising a lot of money. So kind of terms are becoming standard across, and people are giving some weightage to the Indian GPs as well. Like, okay, you are a set. You know your stuff. But just focus on something where you're good at. Don't basically spread your arms and wings all over. So I think from the terms perspective, things are becoming standardized. They are indeed expecting a lot more deep dive into the specialized area versus just spraying everywhere. And they expect you to remain a little bit more open in terms of a communication. It's better to deliver it's a fundamental principle of the communication always works is like, deliver the bad news much early, much sooner. Don't wait for the regular communication cycle. So like this time around, a lot of basically folks have proactively gone to the LPs post-COVID and basically said, look, we're waiting for the reporting cycle to happen, but this is how we see the companies to evolve. The more you do these things, the more confidence gets built up across over a period of time.
Yeah, no, absolutely. And Bharat, I'm going to come back to you for one question on, how difficult is it, from a secondary transaction perspective, when your counterparty is another fund? Is it easier? Is it difficult? Obviously, same fraternity. Does it make life difficult for you because you know the challenges, or is it easier? But before that, I think I just wanted to pick. Take a question with Richie. On Richie, just taking a cue from what Bharat said on LPGP relationships. I want to hear your thoughts on how are you seeing these LPGP relationships evolve, key terms, and particularly in the secondary context.
Sure. See, I think one recent experience we had was more on GP-led restructuring that we saw, where the same GP was trying to add some more life to the portfolio. And for this, they had set up a continuation vehicle. Now this is somewhat unique than what Nishal and Bharat were alluding to, because there it was one fund selling some portfolio to another fund. So there were negotiations going on the both sides. What we are talking about is a continuation vehicle where the same GP is acting as a manager to the current fund, selling its portfolio to another fund which has the same GP only acting as a manager. So here the conflict of interest obviously is the biggest issue that is out there. So the process has absolute value. You need to demonstrate to your current set of investors that how the sale is happening at a fair price. At the same time, because that is where your fiduciary obligations already exist with your current fund. At the same time, when you're setting up a new fund, you need to sort of make sure that you have bought the assets at the fair price, because your carried interest, your economics, everything is aligned insofar as the other fund is concerned at what price you acquire. Now, unfortunately, it is not as simple to say that, okay, one set of fiduciary cancels the other set of fiduciaries. So, on one hand, because I am obligated to buy at the right price, on the other hand, I'm obligated to sell at the right price. So, unfortunately, it doesn't cancel out. Accordingly, you have a lot of issues on valuation coming out. So, as long as a fund manager, you have an absolute set out policy at what price will this GP restructuring sort of move. It is super critical, and it makes both the set of investors comfortable that as a fund manager you've been fair. The other issue that comes up is that in a restructuring of this sort, it is both a fund formation and a M&A exercise being carried out at the same time, because you're setting up a new fund with new set of investors coming in. At the same time, you're moving the portfolio out. Like Nishchal said, it could be the entire portfolio, it could be part of the portfolio. So it is a combination of formation as well as a M&A type situation. So here, how you sort of place the different set of expenses. also a big critical LPGP negotiation item. To begin with, when you're forming the second fund, that is for the second group of investors to acquire. When you're selling a portfolio, it is as a selling fund house, you have to pay up the expenses. And if the transaction does not go through, you'll have to look at it as a broken deal expense. On the other hand, as a buyer, you are acquiring a portfolio, so there may be some costs attached to the acquisition, which you'll have to bear. So how you sort of write those rules upfront before undertaking any exercise is super critical. I think a bad thing that can happen is midway while you are playing the game of doing this GP-led restructuring, some issues come up which you have not thought through. That's when the investors on both the sides, your existing fund as well as the new fund, tend to get little agitated. Now, like Bharat indicated, investors are not unique to a particular fund. They're also matured. They've also gone through different GPs. They've seen the behavior of different fund managers. That is where, in the case that I am referring to, we saw a group of LPs who have gone through different exercises of similar nature, and they share a lot of experience. I think that is of significant value, because the moment you have your LPs, your advisory boards in confidence, the moment you have your larger LP bases comfortable with what you are trying to undertake, then it definitely smoothens the process. Otherwise, this is one of the most heavy lifting exercises one can think of in a M&A plus fund formation context, because your fiduciaries are all over the place. As a seller, it is different. As a buyer, it is different. As a fund manager, it is also very unique, and so on and so forth. So I think that is how I would look at it. Obviously, we have seen some smaller situations also where some existing investors sort of roll over to the new fund. In that case, sometimes the request is that can you look at a combined carry calculation? Like, instead of looking at the carries uniquely for the previous fund and the new fund, give me a combined carry so that as the fund manager, you have preserved the value across the two situations. I think those are the negotiation items we have seen. Yeah.
I think just to add to what Richie said, in the fund formation plus M&A situation, in fact, we faced a very interesting situation in one of the portfolio buyout deals where there was no issue with respect to other portfolio companies since the selling PE fund had minority stake. But there was one entity where they had a majority stake and they were selling it to the buyer PE fund. Now the GP was going to remain the same. So the selling PE fund was selling this 4 or 5 portfolio companies to the new PE fund that was going to be formed, and the GP for the old selling PE fund and the new PE fund was going to be the same. Now the issue that came up was who will give business warranties, because it was a controlled transaction. As far as the new PE fund, which was the secondaries buyer PE fund, they wanted extensive reps and warranties from the selling PE fund, because they were pretty much controlling the entire company. The selling PE fund's LP said that the GP was managing everything. How can we give any business warranties? The GP said, how can I give business warranties, because I only get management fee and carry, right? And I'm actually even continuing with the new one. So interesting issue where all three of them had valid arguments. Finally, where we settled, we had two options. One was to take very limited set of business warranties in the form of financial statements, which took a lot of convincing for the LPs of the selling PE fund to give. And they finally agreed in the interest of closing the deal. And the second option was obviously taking a warranty and indemnity insurance for the deal, where the selling PE fund will pay insurance premium to the insurance company and take care of the risk, or rather pass on the risk to the insurance company. So as Bharat and Richie mentioned, there are so many issues like this. These are just few issues that we have discussed, but there are many more issues which one faces in either of the three models, whether it be LP buyout or GP buyout or portfolio buyout type of situation.
So Nishith, let me ask you one question, and I think since we only have like 5 minutes left, maybe very quickly on the same thing, that when we talk about there's obviously over reliance on the R&W insurance. Without taking any steam away from it, I think there has been one case where the insurers have rejected a large M&A insurance. So it obviously sent a little bit of apprehension in that. But so Nishith, I think the question is that how would people deal with the sort of the out from an R&W insurance, where because R&W would naturally not cover any sort of known risks. And to that extent, it will be a specific indemnity matter. So how is this being treated, and how do you see practically, this being covered? Because at the end of it, the seller probably might have his fund life finished, and so do you do it through sort of side start vehicles, and how you've seen it? Very quickly, please.
So I think the way this is negotiated is, the buyer takes a call that if there is any breach of warranty, the insurance company will make good the loss arising on account of breach of that warranty. So to that extent, that is a risk which the buyer takes. So in a situation where the insurance company is rejecting the claim, the buyer is completely exposed because typically no seller wants to pay premium to the insurance company and still take on the liability that if insurance company rejects the claim, they will make good that claim. Otherwise, then there's no point in having insurance in the first place and paying the premium. So it's a call which the buyers typically take, and as you rightly mentioned, most of the situation, the seller PE fund is going to get wound up, after the exit, and hence, especially for let's say indemnities with respect to tax, 7 years, and all those things are impossible to meet with those timelines. So this is how typically it happens. Buyer takes the risk of the insurance company rejecting the claim.
Got it. All right. I think we are just about 2 minutes. Nishith, anything you want to add? I think we had a last question on wish list that I wanted to check with you and Richie on. What are we hoping? What are the key considerations that LPGP secondary fund should look at? But do you want to take up a wish list or the kind of thing, or we finish? It's only 4 p.m.
I think, maybe all panelists can chime in, but I think few things which will at least make things easier for secondaries funds. Yeah. One is clearly, especially, there are many AIs in India which have a larger retail base, and wherever the non-institutional unit holders are there, it becomes difficult to get 75% approval. Not because they want to reject it, but because most of the times the unit holders don't revert when they're asked about giving approval for change in control of the manager or the sponsor. So I think there it's important to have some kind of threshold from SEBI's perspective that as long as the manager has validly through legal means and valid courier, whatever, registered AD, they have communicated to the unit holders about the fact that they need to give approval, and if unit holders don't approve, then those unit holders either should be considered as deemed consent, or they should be excluded completely from the denominator and the numerator, so that you can just consider people who have responded versus people who have dissented, and then take a call whether 75% threshold has been met. So that ambiguity should go away because that will at least help in increasing the GP buyout activity in India. I think the second important point is the CCI approval, where again some guidance from CCI would be helpful in situations where the control at portfolio company level is not changing, but the control of the manager is changing. Then what should be considered for the purpose of determining the threshold for making application to CCI? Should the fund which is managed by the manager be holding more than 50% for the application to be made, or is there some other threshold that should be there? So I think the GP buyout and CCI approval, I think that should be clarified further by CCI, because there are a lot of views in the market floating around on when to approach CCI, when to not approach CCI. I think these are the two important changes which, if made, would at least make life easy for GP buyouts.
Right. I think, and from my perspective, just to quickly add, I think the AIF regulations now allow category 2 AIF invest in other category 2 or category 1 and so on and so forth. So I think AIFs as a buyout vehicle situations in other AIFs is possible. GP buyout also, we have seen SEBI being very comfortable that if the manager is not performing, investors do need to retain the right to sort of remove the manager or have a complete secondary of the manager position. I think the issue that is hampering is the use case of the AIFs. A lot of the views taken by the regulator today seem to be influenced by a more retail type product. Fortunately for us, have been institutionalized sufficiently. The ticket size itself is 1 crore plus, which is a sufficiently large number, so that the regulator can allow the fund manager and the investors to sort of design commercially what they want. I think one issue that Nishith pointed out on this entire consent from investor base, I think a lot of the newer funds that we're designing ground up to begin with recognize some of these situations under the conflict of interest clauses and very clearly identify that in case such situations were to arise, this is how the entire decision making process will work and accordingly and how the voting mechanisms will also sort of play out. I think those were the two thoughts on this.
Great. Good. Then, great. Thank you very much. Thank you very much, Richie, Nishil, and most importantly, Bharat. Thank you very much for making it and wonderful insights and inputs. Nishith I just
say hello to Bharat and thank him very much. I've been on the the session right from the word go. So Bharat, you brought excellent insights into the whole syndrome, and very nice. Thanks a lot. I think we should catch up sometime and do it some of the interesting more often. But it was very helpful. And Richie, Nishchal, I think you all have been, wonderful to have interaction with. So thanks a lot, each one of you, and appreciate. Thank you.